Good evening. My name is Dennis Pelkie. I'm a lawyer with Parlee McLaws. I practice here in Calgary in the area of wills. I've been invited by the deaf community to speak about preparation of wills, points that you should consider, such things as who should be your executors, who would be your beneficiaries, who would be the guardians, and the overall considerations that you should have when you are preparing a will. What are wills? A will is a document that you prepare that deals with your estate assets when you die. A number of people are concerned about what they should put in their will, and these are some of the things that they should think about. It was interesting, when I came in tonight, I talked to a number of the people that were here, and surprisingly, almost half of the people don't have wills. In Alberta, approximately half of the people don't have wills. Other people that I spoke to tonight had wills that were 10 or 15 years old. So even though you've done a will, you should consider these points, even to know whether you should redo your will or whether you should prepare one. Now, as I said, a will is a document that distributes your estate assets to various people that you want to name as your beneficiaries. But the first thing that you should consider is who would be your executor. The executor's role is to take in your estate assets, distribute your assets to those beneficiaries who you want to receive it. People have an idea that a beneficiary should not be an executor, but an executor can in fact also be a beneficiary. The typical situation in a husband and a wife circumstance is that the spouse, the surviving spouse, would be the executor for the deceased spouse. But you can't stop there. You also have to consider who would you want to be the alternate executor. The alternate executor would be the person who would step in when the primary executor couldn't act, either through death or because of a disability. Now, the executor's job, as I said, is to distribute the assets. The key thing that you should consider when choosing an executor is the person trustworthy, and will they see a task through to the end? If they don't have any business acumen or a lot of business acumen, that is not as important, simply because they can hire people who can give them advice with respect to what they should do with their assets. Now, once you have chosen your executor, you should then consider who would you want to be your beneficiaries. Again, in a husband and wife situation, typically the spouses leave everything to each other. They have worked together to grow the assets. They want to use the assets for each other, so they typically leave everything to their surviving spouse. The circumstance, though, is a little bit different if both spouses die. Who then do you want to leave your assets to? Typically, people want to leave their assets to the children if both spouses die. In Alberta, if you leave anything to your children, if your children are under the age of 18, the children are not entitled to receive the funds because they at law are not considered adults and therefore do not have control of the funds. So what you should consider with respect to children is, if they are under the age of 18, to set up certain trusts for them. You can set up a trust where the executor, that's the person who has been administering your estate, can use the funds for the care, education, maintenance, and well-being of the children until they attain a certain age. What sometimes happens is people suggest to me that what they would like to do is have their children to have the funds when they attain the age of 18. My question to them is, what were you like at age 18? I know that if I had received a large amount of money at age 18, I would have had a great party, maybe two, lots of friends, fast car, no money by 19. So what I encourage them to do is to hold on to the money. Have the children receive the money in two stages. The first stage at age 22, perhaps by then the child would have finished the first degree at university or technical school or college, and would have a little bit of maturity, might be able to handle money at that point in time. And if you only give them a third of their share, they would get the experience of handling money and would learn that money does disappear if one doesn't spend it wisely. What you would also consider doing is giving them the second stage at age 26 or 27. The second amount would be kind of the last opportunity for them to receive money from the estate, on the theory that if they can't handle money at age 26 or 27, that they're probably never going to be able to handle money. And you cannot typically rule from the grave, at least you shouldn't. So the next question that happens, or the next question I'm asked is, well, what happens if my children die? What would happen to their share of the estate? The question that I usually ask then is, what do you want to have happen? Do you want the money to be shared only among your children? Or if your child dies and is survived by children, do you want those children to receive the share that their parents would have received? So you can have a situation where it goes first to the spouse. If the spouse isn't alive, then it goes down to the children, shared equally. And if the children aren't around, it can then go down to grandchildren. Because the subject of wills can be a somewhat depressing subject at best, the next question that I ask is, what happens if all of the family members die? You should consider what happens if your spouse dies and your children die and there are no grandchildren. Who do you want to receive your share of the estate? Do you want it to go to a charity? Do you want it to go to certain family members? These are points that you should consider when giving instructions with respect to the preparation of a will. The notion seems to be that if there is some money that is undistributed, that it automatically, under a will, that it automatically goes to the government. That's not the case. What happens is it goes by a statute in Alberta that distributes the estate to certain family members. The problem with that is that goes according to how the government has suggested it should go rather than how you want it to go. So it's very important that you consider who you want to be the beneficiaries and at what point they are to receive their share of the money. The next point that you should consider is who would be the guardian of your infant children. Surprisingly enough, we do not necessarily control where our children go. We have the opportunity to pay for where they are, but we don't have the control of who receives them on our death. It is but a statement of intention. The ultimate decision-making is made by the courts. If, though, you put in a will who a guardian is, the courts in all likelihood would confirm that appointment. What is the test for a guardian? Typically, a guardian is the family member, and they are the person in the family who has the closest ideals and beliefs that you do. They have the same values in life. They are the people who want to treat their children as closely as you treat yours. The decision with respect to guardianship is very important because they are the ones who are going to be entrusted with raising your infant children and ensuring that they are brought up to the best of their ability and as close to your ideals as you want. The last point that you should consider is, what is an estate asset? We've talked about distributing assets, we've talked about the beneficiaries and the guardianship, but we haven't said what's an asset. An asset is something that is owned by someone in their own name at the time of their death. Now, if a house is owned between a husband and wife or between a couple, and it is jointly owned, it is not an estate asset if one of the joint tenant dies. It automatically goes to the surviving joint tenant. The same would apply to a bank account. If you have a bank account that is joint between individuals, it goes to the automatically goes to the joint survivor. So what you have to decide is, what are my assets if I die at the time of my death? What do I want to have disposed of? What do I own by myself? What do I own jointly with another? So when you're considering preparing a will, you should know what your assets are. If you have an insurance policy with a named beneficiary, that insurance policy proceeds are paid to the beneficiary. If it is payable to the estate, then it is an estate asset. So when considering your will, know what your assets are, know what the amount is, and consider all of those things when preparing your will.